Pardon, my lord, mentioning. Pardon, my lord, mentioning memo. CRLA number 908 by 2022, my lord. In this case, I have filed an IA for interim bail. Mother of the appellant is seriously ill, and in the meantime, she has been hospitalized, my lord.
What is the detention period?
My lord, RI for 10 years. Detention matter, it was rejected by your lordship, my lord.
It's a single judgment.
Yes, my lord.
Give the memo if you
Okay. Kindly next week. Okay.
Item 42, my lord. Item 42, my lord, on 2nd July, I have mentioned that this matter may be taken up on 18th, but it has been listed to this week, my lord. Since my cousin's Shraddha was completed last night, that's why I have not prepared. It may be taken up on 18th, my lord. The date has been already fixed last week. Item 42, my lord. Sudhagara Tilakani was prepared.
44. Patnaik, it is 44, I think.
Sorry,
JCR
sorry.
82 up to
Yes,
2000.
my lord. Yes, my lord. Yes, my lord. Yes, my lord.
So we are not passing any order because it's a 2010 jail criminal appeal. So we are for this week we are not taking of this matter. Okay.
Yes, my lord. Yes, my lord. I am obliged, my lord.
Yeah.
Pass over item number 14.
Maybe. Here the appellant is
There are two CRLA, Mr. Chan.
1405 of 2017, filed by one co-convict.
No, you will move the both the.
No, only CRLA 210 of 2017.
So how many appellants are there in this?
The only one Kisu alias Kishore Chandra Mishra, alias Prabhasis.
So it's a 302 case.
Well,
and since when you are in custody?
I'm in custody, my lord, from 24/6/2011.
Okay. Your bail application was never rejected by this court.
Twice, my lord, has kind enough to grant me an interim bail.
On what date?
My lord, the interim bail, my lord.
Earlier.
IA number.
No, just
1440 8/11/2019.
8/11
2019.
Just a minute.
Which was extended from 12/12.
For a period of 4 weeks, you are granted.
Again, it was extended for on 12/12/2019.
8/11/2019. Extended
12/12/2019
for another 4 weeks.
4 weeks.
Okay. Then what happened?
No, thereafter, I have surrendered and in time and in custody.
I think it is extended for another 3 weeks on 10/1/2020.
I'm sorry, then, my lord, I have this.
Then what happened? Interim bail is extended by another again extended 29/1/2020. Okay. Then the IO has been disposed of. So you are granted bail for the first time on that day, 8/11/2019.
Interim bail.
Interim bail. Prior to that, you have never been.
No.
So what is the prosecution case?
The prosecution case is, my lord, on the fateful day when some college students were playing cards, it is alleged that because of one love relation with between Kamal Lochan, one of the deceased, because two persons have died, my lord, and Kamal Lochan, there are 5 to 6 persons in a car. They reached there and they assaulted Kamal Lochan, including one Sangram Mahanti, and one died at the spot. Another, my lord, was taken to hospital where
So there are two deceased.
my lord,
One is Kamal, another
Kamal
is
Lochan
Sangram.
Dalai, and Sangram Mahanti, my lord. And after conclusion of investigation, charge sheet was submitted against 6 persons, out of whom three faced trial in this particular ST case number. One has been acquitted, two, the co-convict who has preferred criminal appeal 405 2017, and the present appellant, both were convicted for life, my lord. And so far, in the meantime, one juvenile is there. He has faced the trial. He has been acquitted with the same charge, my lord. And another person, one Happy alias Alok Raut, my lord, he is also subsequently arrested after some time.
What are the materials against you?
My lord, the materials, my lord, out of 7 eyewitnesses, 4 turn hostile. Now remaining person, PW4.
Who has supported the prosecution case?
PW4 to this extent.
PW4 then?
PW4, PW6 and PW20, my lord.
PW20. Okay. What is the evidence of the eyewitnesses? What
so far PW4 is concerned, it is his evidence that after he has not named the present petitioner to have assaulted, but it is his case that after the commission of the crime, the all the persons,
trial court report, just
all the
again. PW4.
Mal.
What role has been attributed to
it is his evidence that after he has not attributed any specific role against the appellant, but it is his evidence that after commission of the crime, all the accused persons get inside the car, which was driven by the present appellant, and all of them fled away from the spot.
So 7 to 8 persons came to the college union office veranda, being armed with swords. So assaulted both the students. I immediately rushed to the college union veranda, found Munna not facing trial, was assaulting the deceased Sangram by means of a bujali, and Leighton stabbed the deceased. Who is Leighton?
Not the appellant.
What is your name? This is
Kisu alias Kismal.
Achha, Leighton stabbed the deceased Kamal Lochan Dalai by means of a gupti. Seeing me so and so. Ran away. So Munna Ujali blow to Sangram. Then Kamal Leighton.
The co-convict has been.
Leighton is Gupti to Kamal. What are the injuries sustained by the, as per the PM report? Period 20 and 20, sorry, period 22 and 22 and 24 are the doctors. These are them. PW22. And my role has been ascribed to in the last part of the Malad, same para, which Malad has now gone through Malad. The last para. Oh, there are a number of stab wounds. It is not that one person, he has noticed only one, but PW22 indicates that 1, 2, 3, 4, the five stab wounds, and apart from that, cut wounds are there.
PW6, Jitan Biswal.
Jitan.
Out of those 7 persons, 4 to 5 persons were armed with weapons like Gupti and Bujali. Accused Prabhasis Misra, the present prisoner, and another, namely Munna, who is not facing trial, but hold of Kamal Lochan Dalai from his back.
In the cross-examination, he has said,
his backside, and dragged him near the top of the step of the veranda. Thereafter, accused Prabhasis Misra, Litan, and Munna, who is not facing trial, assaulted deceased Kamal Lochan by means of Gupti. Seeing this, deceased Sangram came to his rescue of someone. At that time, Munna assaulted Sangram Mahanti by means of Bhujali.
This he has admitted to be a development and not stated before the police at para 10, my lord. For the first time,
You are issue.
Kisu alias Prabhasis also, my lord. Kishore alias Prabhasis, my lord.
So PW6 has specified some rule against you that you and another got hold of that Kamal Lochan from the backside, then dragged, and then you, Litan, Munna, they assaulted the deceased by means of Gupti.
My lord. In the cross-examination para 10, madam, I can see of the same witness. Second para, madam. It is a fact.
Paragraph 10.
Paragraph 10.
Yes.
The second para. It is a fact that I have not stated to the police that Prabhasis Mishra, the appellant, and Munna got hold the such and such person and his backside, the deceased, and thereafter the baranda, but I have stated for the participation of the accused Prabhasis Mishra and dragged him to the such and such. So regarding the assault part, he has not said so much. For the first time, he has
stated to the police that Prabhasis and Munna got hold of it.
But para 10, first is, it is a fact that I have not mentioned before the police the name of Prabhasis Mishra, but I have mentioned his name as Kisu, alias Kisan Chandra Mishra.
Next is second parada buchindi. Got hold of that kahini bole buch. And dragged him so and so. But I've stated so and so dragged the deceased Kamal Lochan below the veranda.
Next para.
What is the
probably confusion with regard to the name of the person?
Because he has got three names there.
Next paragraph, it is a fact that I have not stated before the police the name of Prabhasis Mishra and
so that is what he has been telling.
Alias Kisu,
but
and
again telling you, see, I have mentioned about Kisu. So the name when was asked to the witness with regard to Prabhasis, he is very categorical that I have not taken the name of Prabhasis, but I have taken the name of Kisu.
The next para 11. It is a fact that I have not stated before the police the name of Prabhasis Mishra and
but why are you not reading that? Why are you not reading thereafter? But I have.
Yes, no. Para,
so,
next para 11.
Yes, in para 11 I am reading. Can you read?
It is a fact that I have not stated before the police the name of Prabhasis Mishra.
But after that, you will not.
Not there.
Why don't you say?
Madam, see, I'm not saying that. No. I'm not hiding, madam.
There. But I have mentioned the name of Kisu alias Kisun Chandra Mishra.
Madam.
It is there.
So, Mr. Chan, if you would not have been released on interim bail, it would have been more than 13 years. Right? But since you have been released on bail for about 8/11/2019, it may be for 2 months.
2 months and some odd days.
3 months. Around 3 months. So it is more than 12 years and some days.
Local man.
Anything adverse against that period when he was released on interim bail? That instruction you have to take. That instruction that he was released in 2019.
On 2 occasions, it has also been extended.
At that time, he also did not raise that he is misutilizing the liberty. That is why perhaps it has been extended on, and the last order was passed on 29/1. So two things you do in will take up. One is that you obtain that instruction about any kind of allegation during that period, interim bail period. And another thing about the custody certificate you obtain. Okay, Mr. Chan. This is CRLA number 210 of 2017, Miss case number 547 of 2017. This is an application for bail. The Learned Counsel for the petitioner, Mr. Chan, submits that the petitioner was taken into judicial custody in connection with this case on 24/6/2011, and he was never released on bail during trial. During pendency of the appeal, say appeal lo ye bhar karo order sheet. He was
First female
released on bail for the first time
8/11/2019.
on 8/11/2019 for a period of 4 weeks, which was extended
12/12.
For another 4 weeks as per order dated 12/12/2019, again extended for a period of 3 weeks as per order dated 10/1/2020.
The second time 2 weeks.
2 weeks?
29/1/2020.
10/1/20 ମୁଁ କହୁଛି 10/1/20 ପୁରା 3 ସପ୍ତାହ ହେଲା। Then
ଲାଗୁ ଟେ ଅଛି ତାହେଲେ
on 29/1/2020 for another 2 weeks. And as such, the petitioner has remained in custody for more than 12 years. Let the 12.5 years go down. Let the Land and Council for the state obtain specific instruction as to whether there is any allegation of misutilization of liberty by the petitioner while on interim bail. So also produce the custody certificate from the concerned jail superintendent. Jail ଟା ଅଛି କି ଟିକେ କୁହନ୍ତୁ ତ?
କହିଦେଉଛି ମୁଁ ଦେଖିଲି ଢେଙ୍କାନାଳ or ଅନୁଗୁଳ ମେଲା କନଫର୍ମ
No, you put up this matter. କେବେ ରଖିବା? 22 ତାରିଖ. Put up this matter on 22nd July 2024. Yes. And list this matter along with CRL number 405 of 2017. है ना?
Item 20.
Lord, kindly adjourn this matter next week.
What is your good name, ma'am?
Rebati Lata Panda, R.L. Panda.
So earlier, Mr. Biplab Mahanti and his associates were appearing.
appearing for the informant. I am the previous counsel.
Acha.
Mufti has come and without taking consent, he was filed a plea. But I have no objection in conducting.
It's all right. But ma'am, it is not a healthy practice. You should have, when you are aware that somebody, one counsel is already there and somebody comes to you to engage as the counsel, you should have asked him to bring the no objection certificate. Otherwise, it will go on. And suppose 3 to 4 counsel file power without the consent of the previously engaged counsel, then what we will do? Like in the subordinate court or trial court, what we used to be done in the magistrate, that it is to be asked to the accused that which counsel you want to engage. So if we adopt this practice here, then that would not be a good thing, because now it is live streaming going on. So just if somebody is engaged, just ask your client, bring that no objection certificate. Should have been. He is fair enough so that I have no objection. That's all right, but should be.
In fact, court has nothing to do with this, but we have this practice has to be congenial and among.
Rebati Lata Panda, Land Council is present. Mr. Sahu submits that since a new advocate has already been engaged, he is not interested to remain as the advocate of the appellant. Accordingly, the name of Mr. B. Sahu and his associates shall not be reflected in the cause list henceforth. What do you want, ma'am? Now,
Kindly adjourn next week.
next week.
Next week.
You have received the deposition copy, Mr. Tripathi? Okay. This Pandal and Council submits that the matter may be taken up next week. Put up this matter in the week commencing from 15th. Okay.
Item number 21.
Yes, Mr.
Item 21, yesterday that affidavit was.
What affidavit?
That in fact, the petition is in custody for more than 11 years. And your lordship are there, or your lordship was pleased to direct the state to obtain instruction regarding criminal antecedent, and also as to if you will be released on, is there any
Law and order.
situation? Because informant is earlier, there is a case against the informant that he has committed rape. So 376 case was there. That is the motive behind the case.
Your IIC has not reflected the same, so that is why we
Yes, my
called
lord.
upon
That is reflected in the
IIC.
judgment. That
It
is
was there in the judgment.
that is judgment. It is mentioned.
What is his affidavit? It's all right. IN number 67 of 2019 in persons of the order dated 26/6/2014. Mr. Vishwamangal Sethi, the inspector in charge of Jajpur Police Station, filed the affidavit wherein it is mentioned that the petitioner has got one criminal antecedent, and it was not within his knowledge as he joined and Jajpur Police Station on 15/7/2023. And he has tendered on conditional apology. Stop. The affidavit is taken on record. The IIC should be more careful in future while filing affidavit in the court of law. Yes, what is your submission, Mr.?
My submission, my lord, yes, rest on my lord, there is no eyewitness to the occurrence, and on trial court was convicting me that has taken note of the one of the witness who has stated that I was entering into the house of the.
It's a case under 302.
302, my lord. And informant and his daughter is informant with the son of
No,
the.
you see, you committed a crime under section 376
against the
and against
daughter-in-law of the deceased.
right. And
There are
after you are
years.
released on bail, you committed the murder of the deceased.
That is the allegation,
And
my
in
lord.
that case also, you are found guilty. It's
My lord.
not that you have been acquitted. So this is a clear case where you can you have misutilized the liberty, and uh, if such a case, why will be granted bail?
My
Why
lord,
sympathy will
the
be
case,
shown?
my lord, the case, entire case, the informant with the son of the deceased. She and the daughter-in-law.
No, we are not entering into the merits
My
of
lord,
the case now.
that is correct, my lord.
We are not
my
entering
only,
into the question is that one of the things is to be seen that what is the conduct, how far. Then this is the
my only submission.
telling that you are
My-
misutilizing the liberty.
Well, my submission is also now in the meantime, I am in custody for more than 11 years.
हाँ.
11 years in custody.
Then the paper book must have been prepared or not prepared. Yes, paper book is prepared. Get yourself, we are adding it to the hearing list.
My lord.
Like on the IN number so and so. So it's a continue question. No? The after going through the evidence on record, and since it is apparent that the petitioner was earlier convicted under section 453 376 by 511 IPC in a case instituted by the victim of rape, who is the daughter-in-law of the deceased in the present case, and declared the misutilization of liberty. And since the petitioner has misutilized his liberty, we are not inclined to release the petitioner on bail. However, taking into account the submission made by the London Council for the petitioner, that the petitioner has remained in judicial custody for
11 years.
For 11 years, and the paper book is ready. Let the JCRLA be added to the hearing list dated 29th July 2024. I disposed of. Yes.
Item 30.
Yes, Mr. Panchanan Panigrahi. Yesterday he was there. Not there. Who, he was engaged by the court or by the he ordered him sit on the file provision. Wakalatnama, there is a phone number we asked you to contact yesterday. Let me pass on. Mr. Tripathi was contacting from. All right. Otherwise, we can engage somebody else because yesterday we urged and just ask Mr. Tripathi whether he has. Okay, next.
Item 38.
Item 38, the appellant has been convicted under section 324, 307 and 302 of the IPC, my lord. In this case, I was appointed as the amicus by order dated 24th April 2024, my lord. Appeal is yet to be admitted.
You have got the judgment copy, etc.
My lord, I've got the judgment, but not the paper. Paper book ta paini judgment hai sir deja.
Paper book ko prepare hi nahi kya? Paper book to prepare hi nahi. It is coming for admission. So what is question of preparation of paper book? By the way, what is your years of practice?
5 years, my lord.
5 years you cannot be appointed as amicus curiae in a 302 case. That is against the dictum of the Honorable Supreme Court. Said that at least 10 years of practice is necessary. Mr. Tripathi, well, that decision of you, Lalit, and other decisions are there.
It has been followed
All through that. Minimum 10 years of practice is necessary.
Patra is
Hmm?
about 10 years.
No, just we once we disengage, we have to see assign some region. Where is that tradition? That I eat that out with all the okay. ନାଇଁ ସେଟା ହଁ ସେଇ ଯୋଉଟା ବାହାର କରୁଥିଲ ଲାଇଭ୍ ଲରେ ଚାଲୁନି କଣ? This is not functioning. जो एटी जे ऑपरेट करतला से पड़ा एटी जे ऑपरेट कर नहीं से जो एटा टी पटे जो ऑपरेट करतला छुट्टे थिला पड़ा गोटे दिन पे and एगुड़ा सब टेस्ट हो से एगुड़ा से and why it is not doing. ତା ପୂର୍ବ ଯୋଉଟା ଭାଗ କରିଥିଲା ସେଟା ଭାଗ ସେଇଥିରେ ଥିଲା हाँ अनुखिलाल right अनुखिलाल you are right
2019
please give that reference what is the reference
2019 volume 20 SCC
बाहर करो
196
एटा ऑफ कर एटा देखा जाउनी
and that is also a prescription in our Legal Services Authorities Act because we are he is coming for a prisoner's petition for engagement on the side of government.
all the CPC live streaming of each लाइव स्ट्रीमिंग ऑफ करो, करो, ओपन करो. एक मनोखिलाल केस पर. 31.1. Just a minute. One. 1.1. In all cases where there is possibility of life sentence or death sentence, learned advocates who have put in minimum of 10 years of practice at the bar alone can be considered to be appointed as amicus curiae or through legal services to represent the accused. In all matters dealt with by the High Court concerning confirmation of death sentence, senior advocates of the court must first be considered to be appointed as amicus curiae. Whenever any learned counsel is appointed as amicus curiae, some reasonable time may be provided to enable the counsel to prepare the matter. There cannot be any hard and fast rule in this that we have. However, a minimum of 7 days time may normally be considered to be appropriate and adequate. Any learned counsel who is appointed as amicus curiae on behalf of the accused must normally be granted to have meetings and discussion with the accused concerned. Such interaction may prove to be helpful as was noticed in so and so. In the end, we express our appreciation so and so. Okay. So, learned counsel, you are not falling within this category. So, we have to disengage you and engage another counsel. Yes,
With your name is in the panel or you were not in the panel? You were there in the panel. At least there is one.
What is the bar enrollment number? Your
good name?
Gayatri Patranch.
your
0841
O
841
uh,
of 2019.
2019. That means 5 years, right? After you have your practice is 10 years now.
Lordship, 2013, Lordship, I got the license.
Are you aware of your serial number in the list?
No, Lordship.
No.
No,
So
Lordship.
it's not there.
Okay. Last year they had called me for that discussion.
All right. As for this, said that his enrollment number is 0841 of 2019, and as such, he is having practice of 5 years. In the case of Anokhi Lal versus
State of MP.
state of Madhya Pradesh, reported in 2019-20 Supreme Court cases 196. The Honorable Supreme Court has held as follows for this paragraph number 31.1. Since Mr. Mahanti is not having the practice of, is only having 5 years of practice, we are disengaging him, and we appoint Miss Gayatri Patro, who is having minimum of 10 years of practice as the amicus curiae to assist the court in hearing and disposal of this appeal. Stop. The copy of the prisoner's petition along with the impugned judgment, copy of the impugned judgment, is supplied to Ms. Patro. The name of Mr. Abhishek Mahanti shall not be reflected in the cause list henceforth. Part admit call for the trial court record. In the top of the briefs, also in the cause list, the name of Ms. Gayatri Patra shall be reflected henceforth. Yes. Yes.
Apply, Lordship.
Yes. What happened to Mr.
I have contacted Mr. Kanchanan Patil several times, but he has, his phone number is unreachable. Kalipura.
Mr. Patra, Mr. You want to, Mr. Das? You want to try once again?
Another number is here. So
Just
Number is just.
otherwise, it's a JCRL. We have to engage.
just time call.
If he's not interested, not interested.
No, he is regular.
But all right.
He's coming.
when that order was passed on 25
24th June, my lord.
24th June. अच्छा.
A file.
Course of so-and-so and council so-and-so. This person's recorded is submitted and all relevant questions bringing the substance to the accused to explain and every circumstance. Implementing material concerning the result of the chemical examination as argued by the so-and-so. In the scene of cell and wearing after having patches of blood belonging to the deceased have not been put and disseminated, thereby accused is prejudiced and finding he report cannot be utilized. So this or therefore this court are what will function good and for. That's okay. Then in view of the discussion, the instant case which found that accused has not been material procedure. They are therefore the opinions independent has not been action. The expedient from the questions also. Virtual mode. Presence of the council from us. Okay. And already. Oh, no, the accused statement has been recorded already on 25/6/24. We passed an order on 21/6/2024. That was perhaps relating to that reports, etc., for that consideration of the death sentence. So that report you have already obtained.
Yes, absolutely.
And you have handed it over to Mr.
Yes,
Sadangi.
also I have solved a copy.
Just my lord, pardon, my lord. Mr. Panchana is here, my lord. He wants to tomorrow. Tomorrow, my lord.
Okay. But remain present. You are not yesterday. You are not there. এটা কালি এটা কি what the report says?
So is involved in one case.
Is 39 34.
This one have 34 and that is pending.
That is pending.
Yes, that's still pending.
Which is pending.
That is of the year 2015.
So the incident is of
Pardon?
the occurrence is of the present
20 plus
20.
2020. Took place on 21st October 2020.
Right.
Yes, case accused persons are present. The Navin Deori was.
Sir, kindly unmute.
If Mr. Any affidavit was filed from them by them.
That's it. No, Millers. Actually, I contacted the concerned lawyer. Most of the facts are here. Only one additional fact is stated that before 20 also, because of the trauma that has been given in the probation officer's report, that because of the long-standing family dispute, because out of 7 acres, to be specific, it's not mentioned, 5 acres were taken. 5 acres were taken away, and they were constantly teasing him. For that reason, he was in a disturbed mind. For which reason he was taking medicine even prior to the occurrence. And his son further informed that if he takes the medicine, he is very normal. But the moment the medicine is stopped, now after he is arrested, he is being treated in the jail. So under medication, he is a perfect gentleman.
No,
But
Mr. Karangi, in this annexure A series at page 4, have you got that copy? Please come to that paragraph 1, 2, 3, 4 lines from the bottom of page number 4, annexure A series.
yes, previous medication history of 5 years, 2 months.
No, that is not there. It is that is the office of the regional probation officer, Sambalpur. That dated is 3/7/24. Annexure A series লেখা ହେଇଛି, page number ଦିଆଯାଇଛି 4. ପାଇଲେ ଏ ଯୋଉ 4 lines from the bottom ରୁ ଦେଖନ୍ତୁ ତଳୁ. It is known from the
Neighbors of the convict that the convict family is comprised his wife, one daughter, and 2 sons.
Okay, daughter is married.
Married, one son died
And
before
the
this, much
other
before
is in
this incident.
ceremony, the other
Again, one is in
wife ଅଛି
in his parents' place.
Either
the house is demolished.
No, whatever is not there as per your, if you want to bring it on record, then that is necessary that you should file an affidavit. Either the
no, it's 90% it's there, Millers. That is the
since you say we are to give all opportunities, that is why as per the
even page 7, what I'm saying, it's there. Millers, the doctor, page 7 will also got it. Bimsar Bulla report.
No, if anything has been missed and they want to
he has some prescriptions, but once the doctor report indicates that
affidavit देना दिए सर
नहीं
समय देना
most of the things they have, sorry.
Who is the advocate present?
Yes, ये नवीन देवरी हाँ ओकले अछंती तो
हाँ चलो सर
ଏଇ ଯୋଉ ଆମେ କିଛି ଇନଫର୍ମେସନ ମାଗିଥିଲୁ ତଥ୍ୟ କିଛି ମଗା ହେଇଥିଲା ଜେଲ ସୁପରିଟେଣ୍ଡେଣ୍ଟଙ୍କଠୁ ନବୀନଙ୍କର ତାଙ୍କର ବିଭିନ୍ନ ଚରିତ୍ର ଏବଂ ଅନ୍ୟାନ୍ୟ ଜିନିଷ ନେଇ ସେ ବିଷୟରେ ଆମେ ଗୋଟେ ପାଇଛୁ ଏଫିଡେଭିଟ୍ ଗୋଟେ ପାଇଛୁ ସିନିୟର ସୁପରିଟେଣ୍ଡେଣ୍ଟ ଦେଇଛନ୍ତି ତାର କପି ଆପଣ ପାଇଛନ୍ତି କି
ସାର୍ ଅଛି
ପାଇଛନ୍ତି ନାଇଁ ତ ସେଇ ସବୁ ଦେଖି ସାରିଲା ପରେ ନବୀନଙ୍କ ତରଫରୁ କିଛି ତାଙ୍କର ସପକ୍ଷରେ କିଛି ଆଉ ଏଫିଡେଭିଟ୍ ଦେବା କଥା ଆପଣ ଚିନ୍ତା କରୁଛନ୍ତି କି ଏଇଟା ଦେଖିଲା ପରେ ନା ଯଦି କହିବେ ଆମେ ତାଙ୍କୁ ପଚାରିଲେ ଟିକେ ନବୀନ ବାବୁଙ୍କୁ ଟିକେ ପଚାରନ୍ତୁ ଏଇ ଯୋଉ ଜିନିଷ ତାଙ୍କୁ ପଢେଇକି ଆପଣ ଶୁଣେଇଥିଲେ କି
ହଁ ଏଇ ବିଷୟରେ ଏଇ ସବୁ ଯିବା ଆଗରୁ ତାଙ୍କୁ ଇନଫର୍ମ କରାଯାଇଥିଲା
ଇନଫର୍ମ କରାହେଇଥିଲା ଏଇଟା ଜାଣିବା ପରେ ଆଉ କିଛି ତଥ୍ୟ ତାଙ୍କ ତରଫରୁ ସେ ଜାଣିଥିବେ ଯୋଉଟା ଆସିନାହିଁ କିଛି ଦବାକୁ ଏଫିଡେଭିଟ୍ ମାଧ୍ୟମରେ ଚାହୁଁଛନ୍ତି କି ଟିକେ ପଚାରିବେ
ଆଉ କିଛି ରିପୋର୍ଟ ଯାଇଛି ରିପୋର୍ଟ ଗଲା ସାର୍ ପାଖରେ ଆଉ କିଛି ଯଦି ଆଉ କିଛି ତ ନାହିଁ ପଛରେ ଅଛି ଶେଷ ହୋଇଥିବ ଆଉ କିଛି ଦେବନି ଆଉ କିଛି କହୁ ଏସବୁ ରିପୋର୍ଟ ଭିତରେ ଯାଇଛି he is satisfied
so he doesn't want to file any affidavit anymore and no more fact is there all right yes Mr. Sarangi sorry yes upon your good name lawyer
advocate Subal Gatia
ଆଜ୍ଞା
Subal Gatia
kindly spell your first name
SUBAL
SU Subal
yes
Subal Gardia
Gatia
Subal Gardia we have mentioned it probably earlier
Okay. In pursuance of the order dated,
I have sent it to Mr. Gardia.
yes appraised
when একটা কো অর্ডারে আপন ফাইল কলে অনুযায়ী 21
21st
আচ্ছা as per the order dated 21/6/2024 Mr. Janmijay Katkia, an additional government advocate, has filed an affidavit of the Senior Superintendent Circle Jail, Sambalpur, so also the report of the Regional Probation Officer, Sambalpur, medical documents of the condemned prisoner Nabin Dehuri, condemned prisoner oblique accused like Nabin Dehuri. Criminal antecedent report obtained from OIC Mohulipalli Police Station to also the conduct of the petitioner, conduct of the condemned prisoner Navin Devuri in jail, which are taken on record. The Mr. Subarna
Subal
Subal, Mr.
Gardia.
Subal Gardia, the Lenin Council, who is present with the appellants in jail and appeared through the virtual mode, submitted that he has received the copy of the affidavit along with the other documents which are produced today before this court by the London AGA, and he has also apprised the details of the same to the convicted condemned prisoner, Mr. Nobin Deori. We put a pertinent question. We made a query to the convict Nobin Deori whether he is interested to file any further affidavit uh, with regard to the facts which are not included in the affidavit filed today. He stated in negative. He denied to file any such things. Accordingly, the copy of this also has already been served on Mr. Devashish Sarangi, which is also taken on record. Yes, Mr. Sarangi. So, what is your further submission on this?
It's
One
your lordship
thing,
has gone through this whole thing
if you want to go through
because the person is not a bad character. It's a very individualistic thing.
No, just you have
Not that
just you have received the affidavit today.
yes.
So if you want to go through deep and also study some case laws on this death sentence, we are also ready to give you, because there maybe you can find some decision, suppose on account of some dispute relating to the property.
That case your lordship referred to.
No,
they are also
we said
joint
that,
family property. Two brothers were separated. One wanted to mortgage it.
95 case.
Yes, he refused. Then matter was taken up before the various entries. They said that you give it. Immediately after that decision, he comes and kills 3 persons.
No, that is there.
That is there. And 2 other decisions I cited that how many persons killed, that don't, it's not a consideration.
Those decision you have.
Yes, that cannot be the sole constitution. And factually,
but
if
here we cannot lost sight of the fact that 2 ladies have been killed. Apart from that,
yes,
man,
yes,
here 2 ladies have been also
if
killed.
the overall circumstance, my lords, a person who is very normal with the whole villages, no dispute with nobody, only dispute, and it's virtually ancestral. It's coming up continuously, and major part of his property is lost. It's not in a different area, the same area. His field, somebody else is plowing. His field, somebody else is cutting the.
Where is the evidence?
Pardon.
Where is the evidence to that?
This in
Must
that
be there in the evidence.
No. When
Mr. Bachchan Singh's case, number of
evidence,
number
so
of
far as sentence
murders
part is
also
concerned, strict proof of evidence, if
That is Machi Singh.
Machi Singh.
Yes.
may not apply.
Mr.
Machi Singh is the locus classicus, you can say.
Yes.
Mr. That
But
what my esteemed brother is pointing out in Machi Singh, I think you are saying that number of it is not a matter, but
Yes.
they are also said that if number of murders have been committed during the course of same transaction, that is also a relevant factor which the court can take into account.
Yes, Minister, along with the background.
No, everything is to be considered. So that is why we just now you got the report. So keep it in mind, and we want that should go through it and find out on basing on these things, that is dispute relating to this property is there, and all these things are there, and all those decisions we can take up on Monday itself. There is no because once we write here today that the report is furnished to you and we close the proceeding and pass an order, that would not be proper. Everything has to be kept in mind that we may not know that somebody will say something. So let us keep it on 15th. Okay. Mr. Sadangi, Land Counsel for the Ellen and amicus query, submits that he may be given some time to go through the um, reports filed by the London AGA, and if necessary, will cite some decision on the question of sentence. List this matter on 15th July 2024. Mr. Katki, have you also see those decisions?
I have already I've summarized all the judgments.
Well, the materials actually what I intend, it's there. Because land is one,
two things.
part of it is taken away.
Merit, it is something different.
No.
We are now confining only on the
Sentence part.
Yes.
So what is required, as you said, is that what is the basing on these aspects?
No,
what
the state of mind, you'll also said.
That is also one of the aspects, but it must have to be shown that these are the compelling circumstances, thereby the mind of the
Yes, it was
accused
so
is
prejudiced.
foreclosed, seven except to take, it triggers him to take such a drastic step. That has to be there.
Once there was, let us say, there was a dispute, property dispute. Since long it was there.
Continuous,
So
boiling, ultimately something
what happened on
aggravated.
that particular day?
Because there lies the mystery. Because the PW5, though he has seen that talks about the assault, let's.
No, you are going again to the merit.
Not merit, Minos. Not merit. Now the materials they have collected, it indicates the deceased used to tease him at times. Only for that, there's a mental strain. Now the property is lost, financial hurdle. That day, there is a possibility again the deceased.
Story of the defense saying that my land has been taken away by the deceased family.
No, not.
But there are litigation, and in the litigations
they have own. Yes,
these are all.
No, they have own. I don't dispute that, Milords. But rightly or wrongly, they have own. But the frustration remains.
No. If this dispute was there for several years, why on that particular day he decided to finish all the family members? Three murders in quick succession, two ladies are there. So what happened on that particular day? Why he decided to take this extreme step? Whether there is anything mitigating circumstances, anything to show that yes, this is probably the reason. Otherwise, it would have been
only probability that if the affidavit and the materials are seen, is that ultimately, suddenly there has to be a burst, and it bursted. It's difficult to know.
No.
Or if there would have been some eyewitness person that there was some altercation or something, I would have got some clue. That part is blank.
Health condition, everything is now known to you. The medical documents are before you. Just keep it in mind and give a fresh look to the evidence that why he acted so violently on that particular day. Why he just let us forget about the merit. Merit is
no, I am not on merit.
So
clue would have been there if some evidence would have been there when the incident started. Otherwise, there is no clue.
Whether those aspects can be taken into account as mitigating circumstances.
Before he left the house, till the incident, why it happened, that is a blank area, Milords. There is no evidence from either side. If there, just before the incident, some evidence would have been there that he teased or something, then there is a clue. Now it's clueless. It's only assault part is there. That plot is blank, totally blank.
Always happens in a crime. You can't get the intention of the person.
No intention.
That always
you also said it's difficult to read human mind, why a person behaves in a particular manner. That cannot be the sole basis to assess a person.
This man was not in proper mental condition prior to that. That report has come.
Yes.
Not
Doctor
only
says
that, he used to take medicine also.
Yes.
Is it before
yes.
the
Yes, Minos. The report says past history of more than 5 years. The incident is of 20. Okay. Now we're in 24.
Yeah.
So it goes back beyond the period of the incident.
Medicine.
medicines.
For his mental problem.
Yes.
It is only a trauma, as it is said. It's not a case
No, no,
of
he was
schizophrenia,
under
it's not a case
medication.
of
He was under medication.
depression to that extent, nothing.
No,
See,
because during medication he remains normal.
So,
At that point of time, whether there was lack of medication, that
what that is
that
is
cannot
not
be said.
there. That means what exactly we are asking you to again go through that again. Why it happened on that particular? If it is
Then-
continuing for 10 years,
Then that
civil
itself
litigation
becomes a
service-
ground for acquittal.
No,
If
no,
there is evidence,
It's not a. Here again, you are going to the
no,
merit.
not merit.
That
If there
may
would have
be-
been material, because
that
the
factor
point
may
when
be-
the occurrence took place, that state of mind matters. Whether previously somebody is
no, it is there.
suffering
you
or
are,
after.
you are
To
not.
some extent, it is there. You can see in the evidence also.
Can it be utilized as a mitigating circumstance on that particular day? That is very, in many of the cases, it has been held that for this thing is going on that particular day, perhaps this is the thing for which he took this step. So it can be utilized as mitigating circumstance. So that is in that light we want
That's
to
what
we are giving you
pointing out.
indication
Background is taken,
that
and that part is blank. At least a presumption in the absence of any positive or either
Mr.
side.
Bhatia, you also see whether because
That
it
is the
is-
only reason that is coming to the mind.
No, it is there. Some days back, he was telling to do away with the life of this person, but for a couple of days he was quiet.
Yes.
That was there in
One of the
the
witnesses
whole
have
thing, as
stated.
my senior has just pointed out, while drawing a balance sheet between the mitigating and aggravating circumstances,
Whether this will be
those
enough.
circumstances which are required to be taken as mitigating circumstances to be taken in table. So that has to be done. A balance sheet has to be done.
Yes.
ଗୋଟେ ଜଣ ଜଣଙ୍କର ରିଆକ୍ସନ ଗୋଟେ ପର୍ଟିକୁଲାର ମୋମେଣ୍ଟରେ କୌଣସି ଇନସିଡେଣ୍ଟ କୁ ଦେଖିକିନି ବା ଇଏ କରିବା ତାଙ୍କର କଣ୍ଡକ୍ଟ ହଉ କଣ ଗୋଟେ ସକାଳୁ ହେଇଯାଇଥିବ କି କଣ ହେଇଯାଇଥିବ ହଠାତ୍ ମୁଣ୍ଡକୁ ରାଗ ଚଢିଥିବ ତ ସୋ ଠିକ ଅଛି କ୍ରାଇମ ଅଛି 3ଟା ମର୍ଡର ଅଛି କିନ୍ତୁ ଏଇ ଯୋଉ ପର୍ଟିକୁଲାର ରିଜନ ପାଇଁ ସେ ସେଦିନ ଏଇ ଟାଇପ ର ଯଦି ଆକ୍ଟ କରିଛି that can also be taken as a mitigating circumstance. You would not have acted this way unless that particular situation would not have come. So in some cases that has been taken as mitigating circumstances. ତେଣୁ ସକାଳୁ ଗୋଟେ
best
କଣ ଗୋଟେ
person
ଝଗଡା ହେଇଯାଇଛି
would have been his wife.
Huh?
The best person would have been his wife. She is outside. Now her statement, what the probation officer has gathered, on accepting this dispute and this thing,
No,
that
whatever
part
he has tried
on
to
that
collect
day what
from the
happened,
locality.
that part is also absent. Probation officer.
Wife also has been contacted.
So other things are there, but what happened on that day, that is not there.
You see, when you are giving a person death sentence, you should everything should be
Yes.
before the court.
Every
Nothing, no stone should be left unturned. ଯାହା ଏପଟକୁ ଆସୁ ଆଗ୍ରାଭେଟିଂ ହଉ ସେଇଥିପାଇଁ ମିଟିଗେଟିଂ ହଉ ସବୁ ଜିନିଷକୁ କନସିଡର କରିକିନି ହିଁ ତାକୁ ବିଚାର କରିବାର କଥା ଯେ ଏଟା ଠିକ ଅଛି କି ନାହିଁ ତେଣୁ so let us take it out on 15th. Yes, any other matters? Niranjan Malik. Niranjan Malik is there. Okay. ଆପଣଙ୍କ ଟିକେ ସାଇଡ ହେଇଯାଆନ୍ତୁ ତାଙ୍କୁ ଇଏ କରନ୍ତୁ କାଉନସିଲ କୁ ଟିକେ
ठीक ठीक
तो आपनको प्रेजेंस प्रेजेंट करिवार ता पाखरे हियरिंग बेले उद्देश्य होची कहि दियंतु.
Counsel, your good name?
A. Kamal Lochan Das, my lord.
Kamal Lochan Das.
Yes, my lord.
Again, kindly repeat. Kamal Lochan Das.
K. Kamal Lochan Das, my lord.
A. Kamal Lochan Das. अच्छा. आपन को एंगेज करिवार उद्देश्य आपन कोहा हिची कि?
Yes, ma'am. Yes, your honor.
कौन करिवे?
On behalf of this accused person, so I must pray for consideration of the prisoner's petition. I mean, pending before this honorable court dated 30th April 2024.
No, he has engaged his lawyer. So before us, he has engaged a lawyer. What is required for you to only make the prisoner explain the proceedings whichever is going on here. ତାଙ୍କୁ ଆପଣ ଏଇ ଯୋଉ ପ୍ରୋସିଡିଂ ହଉଛି ଏଇଠି ସେ ଦେଖିବେ ଏବଂ ତାଙ୍କୁ ଆପଣ ବୁଝେଇଦେବେ.
Yes.
ଯଦି କିଛି ତାଙ୍କର କିଛି କହିବାର ଥାଏ ତାହେଲେ ଏଇଠି ଯୋଉ ଓକିଲ ଉପସ୍ଥିତ ତାଙ୍କ ତରଫରୁ ଅଛନ୍ତି ତାଙ୍କ ସହିତ ଯୋଗାଯୋଗ କରିକି ସେ ପୁଣି କହିପାରିବେ.
Yes, my lord.
So you are the person to communicate between the prisoner and the lawyer who is representing him in this court.
Obliged, my lord.
Yes, what happened?
Within 10 minutes, Mr. Panda is there is batch matter in
We are collecting
The conduct of the
that we have to read passing an order today, and it is obviously will give you some time and take up this matter in some other day. So that when the date will be there,
Yes,
we
ma'am.
communicate to you.
Madam.
Okay. Another matter, this is Attakota matter. It's not what the Pujin much.
Sir, colleague ଅଛି.
Kali special. Oh, ठीक है sir. So that's one of it. So any other matter is ready? Yes, Mr. Patnaik, item number 39. Why? What is the problem? It's a 2010 jail criminal appeal, and we have engaged him. So
ଆମେ ଗୋଟେ ଅର୍ଡର ପାସ୍ କରିବୁ, ସେଟା ଅର୍ଡର କପି ଯିବ, ଠିକ ଅଛି?
ତାକୁ ଇଏ କଲେ
order pass ହେବ ଆଉ ସେ order ର copy
ନାଇଁ ଇଏଟା ଭିଡିଓଟା ଲିଙ୍କ କରିବେ, କାଟି ଦିଅନ୍ତୁ, କିଛି ଆଉ ଦରକାର
ତାକୁ ତ ହେଇଗଲାଣି ଆଉ
ସରିଗଲା। ତ